Pushing broadcast now.
Okay.
Good evening, everyone, and welcome to our webinar. My name is Natalie Nahas. I'm the Business Development Manager at the Los Angeles Police Federal Credit Union. Tonight, we're excited to share some valuable information with you all in relation to wills and trusts and estate planning. Our goal this evening is to give you guys an overview of estate planning strategies and things to take into consideration so that basically it can help you guys make informed decisions so that you can choose what's best for your particular situation. Before we get started, I'd like to mention that this session is a live webinar, but you'll receive a recording after the presentation. To keep things manageable, attendees are going to be muted. However, we encourage you all to ask questions, and our presenters will have some dedicated time at the end of the presentation to go over those questions. So we encourage you guys to put the questions in the box below. At this time, I'd like to introduce our presenters for the evening, Mr. Ed Kenglet and Lynette Jimenez, who are both estate planning attorneys that specialize in trust and probate law. Edward Kenglet graduated from the University of USC Whittier Law School. He began his career as a clinical instructor and course director at the Ostro School of Dentistry at USC, and he also served as a judicial extern at the Honorable John E. Ryan of the United States District Court for the Central District of California. Lynette Jimenez was born and raised in Northern California, and graduated from UC Berkeley with a Bachelor of Arts in Political Science and Italian Studies. She later received her Juris Doctorate from Pepperdine Caruso School of Law, and while attending Pepperdine Law, she also served as a certified law clerk at the Ventura County District Attorney's Office. Also joining us tonight is Mr. Chris Ellis, who's a registered investment advisor with the CUSO Financial Services, and he exclusively works with Los Angeles Police Federal Credit Union. He helps our members and has been helping our members for over the last 5 years in providing services in a wide range of areas such as retirement planning, wealth management, savings for minors, along with insight into drop, deferred comp, and IRAs. So we hope that you have a great presentation and that you enjoy it. Without further ado, I'll turn it over to Lynette and Edward. Thank you.
Okay, good evening to everyone that is on this webinar. First, I want to say thank you for this opportunity. On behalf of my law firm, Lynette and I are thrilled to be joining you. Many thanks to the folks over at the Los Angeles Police Federal Credit Union for your good work and for inviting us to speak at this very and timely, important webinar about estate planning and financial planning. I cannot think of a more interesting time to talk about this. My firm has been very busy dealing with the pandemic and all of the emergencies with respect to what's going on in the world, making sure that you're safe, making sure that you have the necessary documents in place to protect you, to protect your minor children and your families. The way I'd like to start is I'd like to go over an agenda, a roadmap, if you will, of what we'll be discussing. First, we'll be talking about estate planning generally, like what to do and what to plan for. And then I'm going to go into what available resources are out there. For example, what is a will? When is a will appropriate? And when is a trust appropriate? And then as Natalie had mentioned, the financial planning part, which is an extremely part of planning generally, will be discussed by my great colleague and friend, Chris Ellis of the Los Angeles Police Federal Credit Union. Another great moment to discuss is this concept of incapacity. So a lot of people think of estate planning like, okay, I'm going to pass away and where's the will? But in fact, it's not that easy, so to speak. Before people pass away, they're generally either physically incapacitated and or mentally incapacitated. Now, a long time ago, 100 years ago, for example, in the 1800s or the early 1900s, people did just pass away because the medicine, the technology, the science wasn't where it is, for example, here in 2020. Whenever I talk about estate planning, I want to spend a little bit of time going over the fact that you will likely become mentally incapacitated first before you actually pass away. So you need to have in your uh, uh, schedule of things with respect to protection documents that cover you if you're still around, but in the event that mentally you're no longer here. So it can strike at any time. And the pandemic, COVID-19, for example, is a perfect example where you can be incapacitated. You're not no longer to breathe, you're in ICU, and you've got a business to run, you've got medical decisions to be made. And if you don't have these documents, unfortunately, that could be quite tragic. So failing to plan means a court could have to appoint a decision maker. Now, this is called a conservatorship in the state of California. And basically what happens is if you haven't left the necessary documents so that your wife or your children, your adult children, or your friend can make decisions for you, literally, they will have to run to court to get an emergency conservatorship. Extremely expensive. So lack of planning increases the burden on your decision maker. Your decision maker might not carry out your wishes because you've never spoken to them about it. You've never reduced it to writing. So part of tonight, we will discuss documents that you need in place, that if you are in fact incapacitated, that you have this in place. And again, part of the reason why I think there are almost 400 of you on this call, which is a record with respect to the police and the webinars that I do over the years. I think this is one of the reasons why a lot of people are concerned and interested. So I'm going to give you some statistics. It's a 40-40-20 split. 40% of people literally have no planning. So we've got famous people like James Dean, for example, like Prince, like Aretha Franklin, all of these people that you see on the news. They literally pass away with no instructions whatsoever. And that's about 40%. The other 40% actually have a will. All right. So I'm going to go over what the differences are between not having anything and then having a will. And then only 20% of people actually have a trust in place. Right. So in this slide with the will, the wonderful thing about a will is that you get to choose who your assets go to. And that could be your spouse, your children, grandchildren, friends, charities. You can even give it to your dog, for example. We have an infamously famous case in Leona Helmsley where she attempted to give $12 million to her pet Maltese, her dog. So that's one benefit of having a will, is that you get to choose. But if you don't have any instructions, like James Dean, for example, the state gets to decide through its laws, and that's called intestate succession. So in the case of James Dean, for example, he was already famous. He was young. He was 24. He was not married, no children, and his mother had predeceased him already. And basically what happened there is because he left no instructions, the state of California gave everything to his father. And for a lot of people, that might be appropriate. But sadly, the case in James Dean was that his father abandoned him and his family when James Dean was born. So the courts got it wrong, but in fact, James Dean actually got it wrong because he made no instructions. So had he left a will, like Marilyn Monroe, for example, Marilyn Monroe gave, I think, 75% to her acting coach. And so that's one benefit to having a will, because you get to decide. Okay. There's one really bad thing about a will, and I will go over that. So a will is not for everyone. So some will basics. A will provides information about who receives your assets, which I went over, how the assets will pass, when your heirs will receive the assets. You can choose an executor. So that's another wonderful thing about a will, is you get to choose who's in charge of giving it out. And arguably you would choose someone that you trust. In your will, you can also put instructions about guardian for your minor children, as well as setting up testamentary trusts. All right. So the one bad thing about a will is that it is subject to this infamous word called probate. Now I'll have my colleague, Attorney Lynette Jimenez, take over and go over some interesting things about probate and the trust, and then I'll be back in just a second.
All right, thank you, Ed. So probate is essentially a court-supervised process, and it happens in two cases, as Ed mentioned previously. The first is if you have no estate planning documents whatsoever, which means you have passed intestate. And then second case is if you have a will, you will be sent to probate court. So there are generally three reasons why we recommend avoiding probate court. The first is that it's a very expensive process. What the court will do is they will take an accounting with the executor of a full value of your estate. So for example, for real estate, that includes things like the fair market value and not the equity value of the property. So for those of you with a mortgage, that's something to take into consideration. Additionally, it's a very time-consuming process. So in LA County, because it's such a large county, huge population, there are many people staying in line to go through the process. So generally, even before COVID, the process from start to finish was about 2 to 5 years total. If you're in a smaller county like Ventura, Riverside, San Bernardino, generally it's 1 to 2 years, depending on the complexity of the estate. And then third reason to avoid probate is because it's a public process, meaning that everything is disclosed. There are certain notices that need to be given to different government agencies like Department of Healthcare Services for things like Medi-Cal benefits that you've received during your lifetime. And so for those of you who prefer privacy, a trust is a very important reason to help you preserve your privacy. On the whole, probate court is it's a very strict process. There's not much room for flexibility, particularly when you have no will. The court, as Ed mentioned, will decide who your beneficiaries are, and sometimes it's not the people who you would like. All right, so a common question I get when I meet with clients is, well, what do I need? A will or a trust? So there are three main things I've listed here on this slide. You would be observed by a trust as opposed to a will. First thing is going to real estate that's for $55,125. So like California, where real estate prices are so high, great weather. Sorry, I think my audio is not working quite well. Let me see if I can fix this.
It's better now, Lynette.
Okay, all right, great. All right, so going back to real property, as I was saying, most homes in California, because we live in a beautiful state, are going to be valued over this amount. So generally speaking, the rule of thumb is if you're a homeowner in California, you would be better served by a trust. And then real personal property, if you take the total value of a personal property, like accounts, things like jewelry, tangible personal property like furniture in your home, if you take all of that and total and it's over 166,000, then that's another reason why you need a trust. Sorry, I think my audio is still being a little bit choppy. Oh, there we go. All right, and then going back to this slide, do I need a will or a trust? If you want to protect them from being in a financially vulnerable situation where you have young adult children.
Hey,
There
Lynette,
might be people.
maybe
Yes,
maybe I can take over because the audio is really choppy and no one can hear. Can you hear me okay, Lynette?
yes, I can hear you. No
Okay.
problem.
Yeah, something's going on. So why don't I take over for a bit and then because
It's really choppy.
yeah,
Okay,
it's
no
garbled.
problem.
Yeah. What you can do is maybe mute yourself and then re-register on a separate phone. If you know how to do that. Otherwise, I'll take over for now.
Okay, thank you.
Don't worry. To the audiences, to the members out there, we've done this 100 of times, and we've dealt with every interesting point. So let me take over here, and hopefully you can hear me just fine. So if you can give me back control in it.
Yes.
Okay. All right. So, do I need a will or a trust? Now, that previous slide that Lynette went over, there's a simplified probate process. And essentially, if you have less than $166,250, or if you own a home, real property that is worth less than $55,425,000, it's a simplified probate process and you don't have to go formally to court. Again, like Lynette said, it's expensive. It's about 8% of the fair market value of your assets if you end up in probate court. Now, the opposite of that is if you have assets worth more than that, 55,425, for example, and personal property over 166,250. So house is real property and everything else, cash in the bank, investments, life insurance, retirement accounts, you add all of that. And if it's more than that, you definitely need a trust, because the benefit of having a trust is that you avoid probate. So originally I talked about this 40-40-20 split, right? 20% statistically will use a trust. Now, why don't more people use trusts? Perhaps they don't have access to the Los Angeles Police Federal Credit Union, who has generously set up this webinar to educate people. It's all about education, and it's all about having the right resources. My colleague, Chris Ellis, is going to come on and talk about how this is all connected with respect to your finances. So again, we are encouraging those of you who are listening to us that fall in this category, more than 55,000, more than 166,000, to consider a trust, because it will in fact avoid probate. And then the third reason is if you have minor children. Privacy, access to trust funds prior to age of majority. A lot of people don't know, but if you have a life insurance or if you have a retirement account, and if you add a minor as the beneficiary, let's say they're 12 years old or 4 years old, the custodian, the insurance company, will not give the money to them. They'll hold on to it until they turn 18, or they'll respectfully request someone to go to court, go to probate, and that is how it will be transferred to them. So a trust is important for those of you that have minor children, because you can privately manage it inside of a trust. That money will go to the trust, and then you have provisions in your trust to choose who's going to be in charge of it. So living trust, it's a legal agreement. It is a contract between yourself that says, this is what I'm going to do. I own it. And just in case I get sick, just in case I pass away, here is what's going to happen. It's very flexible. You can amend it. You can revoke it at any time. And one of the most wonderful things about it is completely private. In probate, unfortunately, the world will know your dirty little secrets. They'll know your assets. They'll know everything. It'll be publicly administered. In a probate process, you have to pay the LA Times, for example, $1,200 to tell the world when to show up so that they can see what your assets are. In a trust, it is private and it is limited just to your legal heirs. So for example, if you have a spouse and if you have any children, for example, those are the only people that will be able to review and inspect your trust if you pass away or if you become incapacitated. A lot of our clients, for Lynette and myself, say that attorneys are funny because we intentionally confuse people. And for my other attorney colleagues, I say yes, because attorneys have this funny way of making up words and coming up with multiple synonyms for something so simple. So here's some terms and definitions. So basically, grantor and settlor is whoever creates the trust, the creator, the owner, for example. The trustee is the manager of the trust assets. And then the successor trustee is whoever you are deciding to take over if you get sick or if you pass away. And obviously, you have beneficiaries. So the interesting thing is, while you're alive, you're both the owner, the manager, and the beneficiary. Your children are not the beneficiary yet until you pass away and until you've used your last dollar, for example. Only if you pass away will the beneficiary change, and that'll be whoever you want it to be. It can be your charities, it can be your children, it can be your dog, it can be your best friend. And then funding the trust, retitle assets in the trust name. So what's critical about this is when you have a trust, you just don't sign a trust. You actually have to fund your trust in the name of your trust. So we use 3 examples: a house, a bank account, and an insurance policy. So what you do is the house needs to be in the name of the trust. So you would update the deed, record it with the county that your house is located in, and it's in the trust. You go to the bank, you update the registration of your bank accounts in the name of your trust, it's done. And then your life insurance policy, if you're single, you list the trust as a primary beneficiary. If you're married, you have 2 options. You list your spouse as primary if you trust her or him, and then your trust as a secondary beneficiary. If you're not sure, or if you're in a blended family situation, I recommend you list the trust as a primary beneficiary, because inside of the trust, you can literally designate who gets what of that insurance policy. So for example, if you wanted to give some to your parents, if you wanted to give some to your kids from your prior marriage, for example, or if you wanted to give some to your spouse and some to your kids, you can all do that inside of the trust. Okay, I have another slide here. So here's this slide that says how it works. So for example, with a married couple, the house is owned by John and Mary Smith. You will transfer that to John and Mary Smith, co-trustees of the Smith Family Trust, dated March 20, 2008. For a single individual, it'll be Jane Doe, transferring it to Jane Doe as trustee of the Jane Doe Trust, dated March 20, 2008. I want to go back to this bullet point. What happens if I fail to assign assets and fund the trust? Unfortunately, that one asset that is not in the name of the trust will be subject to probate. Okay, so that is why it's important to inventory your assets, to sit down with a financial advisor like Chris Ellis over at the Los Angeles Police Federal Credit Union, because I'll tell you, a lot of people don't understand how assets work. For example, on average, people don't understand retirement accounts. They are tricky. There are rules. There is taxation. A lot of people think retirement accounts are like bank accounts and that you just pull out the money and you're not subject to taxes and all these crazy rules. So that is what will happen if you don't put an asset or connect an asset within the trust. Benefits of a living trust. It's revocable. It can be changed at any time. It avoids probate. I would say that's one of the most important benefits. Backup name to step in at incapacity. One wonderful thing about a trust is that it deals with your incapacity. So that first slide that I talked about regarding incapacity, that is important, especially during a pandemic. And then you keep control of your assets. What does that mean? A lot of people who don't have the luxury of meeting with us, with a financial advisor and a lawyer, a lot of people end up giving away their assets at the 11th hour. I'm 80 years old, I'm 70 years old, I'm just going to give my house to my son or my daughter because that's who I want. In a trust, you're not giving away any control. You still control it until the very last hour. And then one wonderful benefit of the trust is that you're protecting your heirs. And this is a little bit complicated. We can further discuss this on your one-on-one consultations, but probably one of the more important things that we deal with when we're dealing with parents is that the inheritance that they give their kids, for example, they want to protect it. So let's say their kids are married, and let's say they're concerned about their kids getting a divorce. There is a way to transfer, to give your kids their inheritance in a way that is immune from a divorce, a subsequent divorce, for example. There is a way, if your kids get sued, for example, or if they have liens or if they have debts, the inheritance that you give them can be immune from those threats. So again, there's a lot of benefits, but statistically only 20% of society take advantage of it. All right, so we have will and trust substitutes. So these are things where people are like, I don't want to do a will, I don't want to do a trust. They're not perfect, but they are substitutes. I'll go over each and every one of them, and I'll talk about some of their shortfalls as well. Just make sure I'm good with the time. Okay, so joint ownership. Joint ownership is that you own it with your spouse. So husband and wife as joint tenants. What that means is if one of you passes away, the other one takes over. It won't go to probate, right? But it needs to be joint tenants, not tenants in common. If it's tenants in common and one of you passes away, that portion goes to probate. Beneficiary designation, life insurance and retirement accounts. That means if you pass away, it'll go to those people if they're still alive, right? The problem with that is you have to pass away. Remember I told you it's not that simple. You could be incapacitated for up to 7 years in a nursing home. Well, if you're incapacitated, those beneficiary designations don't work. A lot of people will say, I have $300,000 at the bank and I've already listed a beneficiary. Am I fine? And I tell them, you're fine if you actually pass away. But if you're in a nursing home for 7 years, that beneficiary designation won't work. Transfers on death are exactly like a beneficiary designation for certain investment accounts. Same thing, it'll work if you pass away. But if you are incapacitated, it will be frozen, will end up in court anyways through conservatorship. Is a living trust for you? It depends, I guess. It's generally prepared by an attorney. There are legal document providers out there like LegalZoom, like We the People. They're not lawyers. They basically sell you the paper. You're supposed to fill it in. There's a cost associated to trusts, for example. And, one of you will ultimately ask us how much this is going to cost, I think, in one of your questions. So I can answer it at that time. And then you can buy or sell assets at any time. When you set up the trust, it's dynamic. It grows with you. So the assets that you have in 2020 might be different in 2025, for example. And so you can definitely change that. Other common uses for trusts, spendthrift beneficiaries. Let's say you're afraid your daughter is a spendthrift and that you've worked all your life, you've been working all these shifts, and then you pass away and then your daughter inherits and goes straight to Neiman Marcus and Nordstrom and spends away at Tiffany's, for example. We can put in these provisions. Minor children, blended families, special needs person. Blended families is the name of the game. More and more of my clients are on a second relationship, third relationship. For example, if father passes away, he has kids that are not the other spouse's children. That is probably really, really important. I call it the Brady Bunch situation. For example, if Mr. Brady passed away, will Mrs. Brady take care of the 3 boys the same way that she's going to take care of the 3 girls? So if you're in a blended family situation, you should definitely consider a trust. And then obviously a special needs, if you have special needs child or relatives, there's government benefits that could get in the way if they inherit more than $2,000. If you have a special needs beneficiary, definitely schedule an initial meeting with my office. So I'm going to go over some of the ancillary or supporting documents, and then I'm going to transition over to Chris. We're going to make sure that we get you guys out of here within 1 hour as we promised, because we've saved about 15 minutes of Q&A. So power of attorney is an important document. It comes with any basic estate plan. It's basically a document that says if I get sick, this person can sign my name to transact business on my behalf. And there's 2 types. There's the durable kind, and then there's the springing kind. I recommend the durable kind because that means once you sign it, it works right away. The springing kind is limited. It basically says, I need to be incapacitated first before this person can sign. The problem is proving your incapacity is so hard. You usually have to get 2 letters from independent physicians, 2 different ones. And honestly, in practicality, physicians don't want to write that letter. You can hire a private physician for $5,000 to $8,000 to write that letter. It's 2 pages. It's very costly. So I recommend the durable one, which is it works right away. And even if you're incapacitated. Taxes are crazy. Taxes are just going to get worse. There's an opportunity in 2020. There's only about 4 more weeks left. If you have a lot of money to gift away up to $11.6 million, that is a complicated topic. Capital gains tax is crazy. There's a proposal to rid of step up and basis, if you know what that means. So what that means is right now there's a benefit in giving your assets when you pass away. You bought a house for $100,000, it's worth $1.2 million. You put it in a trust, you transfer it to your kids. It gets stepped up at your death. Your kids inherit at 1.2. They sell it. There is 0 capital gains because of this adjusted or step up in basis. There is a discussion to remove that. So it's crazy, crazy, and crazy. All right. Healthcare provisions, you definitely need documents to protect you during this incapacity. Living wills, also known as an advanced healthcare directive, has a durable power of attorney for healthcare. So when you sign this document, you're basically saying this person can make healthcare decisions for me. And then you're also waiving for confidential medical information. Everything is crazy. People don't want to share information. But if you are appointing your husband and your kids to make decisions for you, they're also going to need to be able to look at the x-rays and the blood tests, for example, and you're going to need to waive confidentiality. So that is an important document for your healthcare provisions. Probably a top 10 question that we have as lawyers is, when do we review? So for those of you that are on this call, let's see if I can see who you are. There's about 72 of you or so. How often do I review my trust if I have one, if I created one in 2010? If there's a new birth, or if there's a death, if there's a marriage or divorces, if you've moved out of state from Arizona to California or vice versa, for example, a lot of people are moving out of California, changes in estate makeup, if your assets grew or went down, business changes, and then obviously tax law changes. I generally recommend to sit down with a lawyer every 3 to 5 years. All right. So I wanted to make this topic topical, and then I'll transition. Chris, I'm going to go over about 2 minutes if that's okay with you. Estate planning during a pandemic. Here's the 2 things that I recommend those of you that are listening. Number 1, incapacity planning. So for example, if your assets are below the 55,000 and the 166,000, you need incapacity planning documents. Advanced healthcare directive, durable power of attorney for healthcare for decisions, waiver of your confidential medical information, and then durable power of attorney for your attorney for finances. You need that, right? And we can help you with that if you schedule a meeting with us. For those of you that are beyond the 55,000 house and the 166,000 personal property, you need a trust, and we call that a trust-based plan. It comes with a full estate plan to avoid probate, and it includes guardianship for minor children, and then all of the incapacity planning that I just described. Those 2 are important during this pandemic. All right, what we've done to make it easy for everyone, if you're interested, you can conveniently schedule the meeting through our auto calendar scheduler. You click a link, it's there, and you self-schedule. All meetings are conducted conveniently by phone or video because we're not meeting with anyone in person. Send your questions to info@kinglit.com about pricing, about all of that stuff. Now, I will tell you that my firm has been working with the police, the credit union, for many years. We do have special pricing for those of you that are in this webinar, as well as for the employees, generally speaking. I checked in with my office. We only have 62 spots for a consultation through the end of the year. We'll be offering those special pricing for those people who schedule. So if you're interested, make sure you give us an email at info@kinglit.com. All right, let me just transition here. All right, so I'm going to transition to Chris. He's a wonderful colleague and friend. He is a financial advisor. Why is this important? It is important because your assets are what goes inside of the trust. So if I can give you a visual, you are hiring me to build you a car to get you from point A to point B, which is after you pass away to give to your kids. What Chris does is he puts the right gas, the right engine, and the right oil, the right assets in that car, so it will take you to point A to point B. All right. So Chris, I'll give it over to you.
Thanks, Ed. I appreciate that. And this is an example that, as we are now well aware here in the state of California, that the future is electric. And we are going electric now by Zoom meetings, WebEx meetings, whatever it is, that we can bring information to you. And so inside that car is going to be a lot of electronics, I think. Thank you everyone for joining us tonight. We greatly appreciate you having us be able to present this information and to be available to answer questions at the end, because we know that you will have a lot. My role at the credit union is the financial advisor. So I work with CUSO Financial Services. CUSO Financial Services is a nonprofit broker dealer that provides financial advisors to the credit union spaces. I've been with the credit union now for the last 5 years. It's a really great fit for me and my family, and I'm really happy to be working with people who are serving our community, as you members are. With that, we're going to get into taking over from the current slide. I'm going to share with you, here's our disclosure, just making sure that you do understand that I work for CUSO Financial Services. And just like any true financial professional, we go through that disclosure as quickly as possible. The need for financial planning assistance. Right now, during a pandemic, during times when people are dealing with job losses or furloughs, layoffs, not sure if you can retire, but you want to retire, whatever it is that you're looking to get accomplished. You just had a new child or you bought a new home. You want to know what you can do to help provide protection for the future. The credit union provides that through myself. We're going to be looking to add an assistant here in 2021, but we do financial planning for retirement, tax efficient investing, savings for college or for minor accounts, helping to manage your investments in any financial market. This has been a very unique year that we've gone through, and I'm not going to go into a lot of great detail on the market or current investments, but we will touch a little bit on that. And then what's the best practices for your retirement? Each of you have different positions or jobs within the city of LA or outside the city, and you have different retirement plans, so we can help provide guidance. And then lastly, what's the most important thing we're talking about tonight is estate planning strategies. What does that look like and what does that entail? I keep on hitting the wrong button, so I apologize. Here we go. All right. Okay, the objectives for my portion of the presentation. We did a retirement planning workshop that we conducted in September that was a webinar. It is still available on the LAPFC website if you log in and go to the links for the different educational materials that we have. Or if you have any issues, just contact us, we can send you that copy. But we went into more detail about retirement planning, financial planning. Tonight, we want to talk about more of estate planning. So Ed talked about it a little bit. How are my trust taxes, or how are my assets taxed, including my trust? So your trust has a different tax bracket than you as an individual does. And that's important to note for transferring assets on to heirs. Also for estate planning, gifting during your lifetime. So giving gifts now, especially while the gift tax and the estate tax is at all-time highs. We'll go into that on a different slide. And then control of your assets. When you no longer are able to control it yourself, who do you trust to be able to take that over? Tax efficient investing. This is something that's really important because we see at the credit union, we have a lot of people in money markets. We have a lot of people in savings accounts, and they're not getting a lot of great interest. So how do you invest that, get a higher interest rate, but also make sure you're not getting taxed heavily on those accounts? And then just typical best practices for retirement. And we want to be respectful of time to make sure that we're making, giving you the information you need, and the question and answer period is a pretty important aspect of this presentation that Ed and I have figured out doing this many times together. So the decisions you make today impact the shape of your estate for tomorrow and beyond. This slide I always share with people, no matter which presentation we're doing, because it really is important that you take advantage of today. I've worked with too many clients who have either passed away prematurely. I've had two different couples pass away in accidents. One was a car accident, one was a plane accident, and neither of them had trusts in place. And so then I'm trying to help the families go through the probate process. And these were things that both families said that they were working on. They had an attorney, and but at that point it's too late. So I used to say, you know, in case an accident happens, but now I tell people accidents do happen. This stuff happens every day. So you need to take advantage of today and get this done. What assets are protected? Ed kind of covered this a little bit. In retirement, before retirement, in early retirement, later retirement, all of your assets are coded by the IRS in special categories. A 401k is a for-profit organization, a 457 is a nonprofit organization. But what we help you do is to understand what should be my beneficiary, as a person? Should it be my spouse, my kids, or should I put the trust as my beneficiary? If I don't have a trust, I need a trust to at least be a contingent in case something falls through. How is my estate taxed? So this is a very important slide. It's not going to do justice because with compliance, it's hard to put all the necessary information in here. But if you have assets that are in a trust, the tax bracket changes and you can get taxed at a higher tax rate if your assets are in a trust. So how do we protect your assets and put them into specific categories or investments as the trust as a secondary or a backup beneficiary to make sure that this is taxed at the lowest possible tax rate? I love the United States. I know that we're going to have to pay taxes, but it would be much better if we paid less, because the money we do give them, they don't know how to spend it anyways. So let's be a little bit more frugal with what we give to the government, because we're going to go out and spend that. We're going to put that into the economy and help. So that's kind of my my take on taxes. Now, protection of the assets. Depending on how you're invested, do you have a short-term income bucket? Do you have a mid-term income? Do you have long-term? However you're allocated, we can help to make sure that your investments are protected. And that's what I want to get across, is the protection. So you kind of hear a consistent theme coming across tonight. These were the tax brackets. I'm going to skip ahead here. The 529 college savings plan. This used to be a very strategic plan that well-to-do families would utilize, and they would put money into college plans. And if you understand the history of how a 529 college savings plan came about, it was very wealthy people influenced Congress to say, hey, you know what? We want to be able to put money away for our kids and not have to pay any taxes on any gains that we make on this, and use it for college. And as long as we use it for college, let's not pay any taxes on it. And Congress said, hey, that sounds like a really good idea, because that's going to help the youth. That's going to help our country, because our youth is going to get educated. We're going to have smarter people going into great positions and be able to kind of further our country ahead. But really what it was just to avoid paying taxes. Now, estate taxes and gift taxes, I said earlier, we're at an all-time high. So right now, if you passed away, as long as you have less than $580,000, you don't have to pay any taxes on your estate. But less than 20 years ago, that was down closer to $1 million. And if you just think about your home, your retirement accounts, your savings accounts, all of the assets that you have, it might be pretty close to $1 million. And if you had over $1 million, anything over $1 million that you passed on to your family was taxed at 40%. So people said, well, how do I get around that? How do I avoid paying that 40% tax? Well, let's put it into this 529 college savings plan, because that doesn't count towards my estate. So this has not been a major factor, but as many of us know, the tax codes could change for 2021, for 2022. We have a president-elect that has already said that he's going to raise taxes, which also means that he could decrease our estate taxes, our gift taxes, and so the 529 college savings plan could become a factor for people, who are of higher wealth, and we don't know what that number will come down to. Prior to 2018, that number was at $5 million per person. So we assume that it's going to come down closer to that number again, but something to be aware of for the future. Okay. For some reason, okay, there we go. Now, what are the next steps? So these are just things to factor for 2020 and 2021. I'm going to skip down here to the section where it says using a Roth IRA to create tax-free income. Right now, since President-elect Biden has basically won the presidency, and looks like that's going to be our future. We are talking to folks who have high dollar amounts in their retirement accounts. These are people who have the ability to convert that to a Roth IRA. So the tax brackets are currently very low based on the 2018 tax changes. So Roth conversions are an extremely popular thing to do for 2020 before the year end, because 2021, the taxes could change retroactively from January 1st. So these are people who have hundreds of thousands of dollars who are looking to protect it against future taxes that would be higher. So I have one client, we're going to be moving around $100,000 into a Roth IRA. That means they're going to have $100,000 of current income for 2020 added to their taxes, but it's going to be at a lower tax rate from what they might have to pay in 2022, 2023, we don't know. So strategies are extremely important. Working with a financial advisor just gives you an added benefit to be able to, one, protect your assets, and two, to make sure that we're doing the smartest thing to protect as much money and keep it in your pocket. And then navigating stormy seas. The stock market has been a roller coaster ride. COVID dropped it. Everything's come back. We've had some volatility around the election. People were terrified that once, President-elect Biden, if he won, that the stock market would crash. Well, clearly that has not been the case. Now with future tax changes, with unemployment numbers, with whatever may happen in 2021, could we see some negative numbers in the stock market? Absolutely. We just don't know. We can't predict the future. So we provide information, give you the best information possible, education, so that you can make the financial decisions that you need for you and your family. Retirement best practices. This is just a disclosure to let people know that I've helped people fill out, drop and retirement paperwork. Right now, pensions is not meeting with people in person. So if you'd like to meet with somebody in person who can help you with future retirement questions, we are taking appointments in the branches. It's safe. We have plexiglass. I wear a mask. We also do WebEx or Zoom meetings just like this to be able to connect with you and give you that information that you need. There's so much information that everybody needs, and it needs to be individualized. We're going to talk about that with each question that comes in. All of you have your own circumstances for retirement. You have your own circumstances for estate planning. You have your own circumstances for protecting your kids or providing for your kids. And we want to be able to give you that information. So what I do is I put together a financial plan for you. It helps to give you all of your assets in one document. It'll also complete a score that tells you if you're on track for retirement. Will you have the retirement that you want if you keep staying on the current path? But also what this does is it provides the documentation that Ed can then take and say, okay, these are all of your assets that we need to protect. And so then when he puts together the estate plan, he knows exactly what he's dealing with to be able to say, okay, for Mr. and Mrs. X, this is what we're going to do for you. This is what we need to do for this property. If you have rental properties, if you have retirement accounts, if you have savings accounts, he's going to help protect those assets. So I make sure you're on the right path, put everything in, a present with a bow. We're getting close towards Christmas, the holiday season, making sure that we know exactly what you have. And then Ed puts the safe around it and make sure that nothing can penetrate it and that your family is protected. So with that, I'm sorry I buzzed through that because we wanted to make sure we left enough time for questions. The credit union has 2 dedicated employees to be able to discuss wills and trusts and be able to refer you to an attorney that might be close by. Ed is our preferred attorney, or my preferred attorney. He provides the guidance and information, but we want to make sure that we are making this as convenient as possible. So George Regalado and Beatrice Galindo, if you contact them, they will be able to answer any questions and be able to help you at the credit union. And then For myself and Ed's email is info@kanglet. Put that back. Info@kanglet.com, and then my email cellis.cfsinvest@lapfcu.org. This is how it would be the easiest way to get in contact with us to be able to assist you personally. Now with that, I'm going to let Ed take over and handle the question and answer portion of this, and then I'll wrap it up at the end and make sure we're done by 7 p.m.
All right, so we have a little bit more than 10, 11 minutes to go over the questions, and thank you to I think there's about 6 questions, but there's a lot of repeats. Let's take the first one. Is it a write-off for a money gift to someone? And I'm assuming it's a write-off with respect to your income taxes. And if that someone is a non-charitable person, the answer is a big, fat, capital N, capital O, N-O. Now, if you're going to be giving a gift to a charity, a nonprofit organization, it'll be a big fat yes, capital Y, capital E, capital S, yes. But just giving a gift to your best friend or your kids or whatever, it is not a write-off with respect to income taxation. On a whole nother topic, there's taxes if you give gifts, for example. But if you give a gift within the year less than $15,000, there's no reporting, and then there's no gift tax consequences. Obviously, you can give up to 11.6 million in 2020 without paying any taxes. If you give more than 15,000, you have to report it. If you give more than 11,580,000, anything after that is taxed at 40%. Hope I answered your question. A lot of your questions deal with costs, and I think I sort of lured you into asking that question, but I'll save that for last so that I won't get in trouble. Let's see. This one's interesting here. I have an understanding that Prop 19 changes if real estate property is heir to offsprings, it will be at market value instead of purchase price. Don't know what you're asking, but let's talk about Prop 19 because it is a hot topic. It is a hot topic. I'll tell you what it is right now because it might encourage some of you to do something about it. But Prop 19, I think, take effect in February 2021. And you guys better listen to this because it's crazy. Right now, before Prop 19, because it passed, you can give up to 2 types of assets to your heirs, your kids, for example. You can give your primary residence and you can give your secondary residence or residences, right? Primary residence, no matter how much is appreciated, your children, or also if your children have passed, your grandchild will pay the same property tax as what you're paying, okay? That's personal primary residence. Secondary residence, anything after that, like a rental or anything like that, you are protected up to the first $1 million. So the way you do this is you look at your property tax bill on your secondary residence, and if it's below 1 million, it'll also go over to your children and they will pay the same thing. Prop 19 comes in and completely obliterates what I just said and puts in a lot of restrictions. One of the restrictions is that when your kids inherit or take over the primary, they have to say that that is their personal residence, right? Which is an issue. And then it completely takes out the concept of secondary residences. They will get reassessed. So you better look into it. There are wonderful things for you as the person owning the house for Prop 19, and I think that's why it passed in California. But with respect to heirship and inheriting, it's terrible. It is the reason why the phone keeps on ringing, and I can keep the lights on here, Prop 19. So, you know, I love California because California is just a crazy place to live in. I grew up here. I love it, and I hate it at the same time, but I love it probably 1% more. I love it 51% and I hate it 49%, for example. Okay, question 2. My real estate property is joint tenants. If I pass away, is there any taxes that need to be paid, or do the surviving party just submit a death certificate to county tax? I believe you answered question 2. Okay, if I did. So if it's your spouse, for example, husband and wife as joint tenants with right of survivorship, and one of you passes away, let's kill off husband because husband always dies before spouse. No taxes, it's business as usual. Basically, wife submits an affidavit of death of joint tenant to the county, and then business as usual. Let me see if more of you. Now, I want to encourage you to ask some questions because Chris and I are not charging. Normally we charge. All right. Would an early inheritance to your children be considered a tax deduction? All right. So it's not an early inheritance because you're still alive. It's called a gift. An inheritance is only if you die. So I'm assuming early inheritance means you're alive and you're giving it before you pass away. So that's called a gift. Considered a tax deduction? No, no, no. There are no tax deductions with respect in terms of income tax, if that's what you're talking about. So basically, if you want to give an early inheritance, you're basically giving a gift, and same rule applies. You can give up to 15,000 to as many people as you want without reporting it, without affecting you. If you give anything more than that within a year, you have to report it. Taxes will be due if it's more than 11.6 million after that $15,000. But there is no deduction unless it is a charitable nonprofit organization. Okay.
Ed, let me jump in here.
Sure.
If this was an inheritance to a child, let's say a grandparent passed away and they had a grandchild as a beneficiary to some of their inheritance. Taxes are not paid by the beneficiaries. Any taxes would be paid first by the deceased's estate. So the estate would pay any taxes. So that has to be handled on that end. But if you're receiving any money, that would be received post taxes. So your children would not owe any taxes. But again, to Ed's point, there's no deduction either on you as the parent or the child having to file taxes.
Wonderful. Yeah, that's absolutely correct. There are countries that assess inheritance taxes with respect to who's receiving, but in the United States, we are taxing the one giving. So in gift tax, it's the giver who pays the tax, if it applies. And then in estate tax, it's the one that died that pays the taxes, or the estate of. All right, this one already sounds exciting because it says adopted. It says, can an adopted child that has been receiving medical or Medi-Cal perhaps, comma, inherit anything without medical taking it away, even if it's a trust? Okay, all right. So remember I talked about this concept of a special needs trust? I'm assuming when you said medical, it's Medi-Cal, which is federal Medicaid. In order to qualify for federal Medicaid, California Medi-Cal, you need to report assets and have to press assets less than 2,000, things like that. If this child inherits more than 2,000, this child can, the government benefits can be affected. So definitely schedule an initial consultation with our office, and we'll talk about setting up a special needs trust. Now, what's wonderful about this special needs trust is that when you set up this trust and then you pass away, anything that goes to this child will be in this very special trust. It could have $10 billion in it, and your child will still be able to collect benefits, because what this does, it does not compete with what the government is giving. It supplements what the government is giving. So it basically says, government, give my child whatever you're giving, and if it's not enough, then we can go here. So for example, a perfect example that I use, there are certain things that Medi-Cal doesn't cover. Like if she needed a wheelchair, we wanted an electric wheelchair, but they're only giving a manual wheelchair. We'll say, give us the manual and we'll upgrade to an electronic one. So special need trust, I think that's what you should consider. All right, let's see. And then we'll talk about, let's see how we're doing with time. We've got 2 minutes. All right, come on in.
Ed, there was one question. How long does it typically take to have a trust drafted and completed? That came in from the chat session.
Perfect. If you're organized like we are organized, we can get one done within 1 to 3 months. The reason why it would take 2 months, the reason why it would take 3 months is because you're not giving us the documents. You're not meeting with Chris Ellis to organize your assets. I recommend a lot of you who are considering this to organize your assets with Chris Ellis. He can go over the categories, retirement versus non-retirement, and all those rules. So 1 to 3 months is a good standard. We're very organized here. We have everything timed out. And we have 62 spots to meet with you through the end of the year. So I hope you take that. All right, let's see. I'm going to take probably one more, and then I'll take the cost question. The equity, so this is Jim Agnoli. Can I put my primary residence in my children's name without paying a gift tax? The equity is 800,000, 600,000 in appreciation. Okay, so you're giving a gift more than 15,000, which means you need to report it, right? But there are no gift taxes due because the 600,000 or the 800,000 of equity is less than 11.6 million. All right, so that's good. But you're doing something interesting. You are giving carryover basis, not step up in basis. So in your question, it says equity is 800, appreciation is 6. So you bought it for 200,000 and it grew 600,000 to 800. So what you're doing there is you're giving them $200,000 in basis. So if they sell this house, they would be subject to $600,000 in capital gains taxes, 20, 30, 40%. You calculate it, right? If you don't do that and you set up a trust with me, with Lynette, put it in a trust and say, I'll hold on to it. If I die, it'll go to my kids. The 200,000 basis will get adjusted to 800,000. Your kids inherit it. They sell if they want to. They pay zero capital gains, zero capital gains. So I tell people, if you want to do this with assets that are not highly appreciated. This has appreciated over $500,000. This is a no, do not do it. Come to me, come to our office, and we'll help you preserve. So what's crazy about this, this happens all the time, by the way, so I'm not targeting you. I'm so glad that you asked this question because you asked a question that hundreds of people are itching to do. And the only reason why we can prevent this is obviously through this forum, for example. So you come to us, you pay for the trust, and it will be much cost savings with respect to cost savings. In fact, the taxes that are due on the 600,000 might be more than probate. So you might as well go to probate because probate will be cheaper than these capital gains. Now,
yeah, Ed, to tag on to that, I had a member come in one time and he had 5 properties and he had 5 kids. And he put each kid on a property and said, I'm going to leave the properties, and based on how much they're worth, that's how much I love my kids. And I said, well, I don't think you factored in taxes. And he said, what do you mean? And it came to a point where he didn't realize that his most valuable asset had the lowest cost basis. He paid $200,000 for it. It was worth over $2 million at this point. And the child that he was going to leave it to would be responsible for the taxes on 1.8 million if she were to sell it at that point. And he didn't realize that. So when I was going through my presentation, I kept on talking about the taxes and estate planning, and that's what I meant. And I apologize for not kind of going into more detail on this, Jim, but keep going, Ed.
So let's go over the $1 million question. And again, if the people in charge look at the Q&A, they're all wanting to know about the costs and stuff. Now, this is me. I want to give this in context. We've been doing this for a very long time. I'm the only lawyer inside of the Los Angeles Police Department in the Employee Assistance Unit. I'm the guy. I do all of the education inside of the police department. And then I'm the only presenter with respect to the Los Angeles Police Federal Credit Union. I'm the only guy that's been doing this. Yes, there's a lot of people in the network with respect to geography. So if you call the reps, they'll look at your zip code and they will assign you to perhaps someone that's closer. But in terms of the education and the presentation, I'm the guy. So here's the cost. Incapacity planning, this is if your assets are below, that starts at $1,425. That's so important for the pandemic and for COVID-19. That's a special price. And it's, if there's a couple, we've reduced it down because a lot of you guys are married, that's $2,000. Trust-based planning, it's a difficult question, but that starts at $2,850. Obviously, if your assets are complicated, a lot of senior staff, a lot of command staff, you guys have multiple properties. I know who you guys are. I think a couple of captains are listening to me now who are my clients. That starts at $2,850. But if you have multiple properties, if you have Brady Bunch of a situation, if you have complications, that, you know, that all builds it. We can only tell you what the final price is during the consultation with the attorney. Remember the big picture here. The big picture is we need to protect you. We need to protect your family. I know there are people that are much cheaper than me that are saying that $500, $900. they're not speaking tonight. I am speaking tonight, and that there's a reason why I'm speaking tonight. I'm vetted, I have the background, I have the experience, that kind of thing, but I don't compete with anyone else. I know the world is big. It is what it is. I wanted to say thank you. I have grown up most of my life since age 5 in the city of Los Angeles. I am pro-police. I can't imagine a more difficult time with respect to what you guys are doing for our city. It is wonderful. So I wanted to tell you, protecting my family, my parents still live in LA. Thank you so much from the bottom of my heart for doing your wonderful and your honorable job. I thank you on behalf of my family. Thank you for your good work, and I look forward to meeting you very soon. I'm going to give it back to Chris, the official LAPFCU employee on this call. I'm an outsider, so to speak, but Chris, I'm going to have you take it away.
Thank you all for attending tonight. We do appreciate it. I know Ed shared his price and talked about, you know, the cost that's associated with it. I'm going to share two things before we depart tonight. The first thing is I spoke with a gentleman this afternoon who was driving back to the state of Washington, where he lives, from Los Angeles. And we talked about him finishing his trust. And literally the words he said to me were, I just got to get my paperwork together and I got to pay the price. He has multiple properties. He has a business down in Mexico. He has so many things going on. But what if he gets into an accident on his way home? Knock on wood. What if something were to happen? His family's going to have to go to probate to be able to get that. So take control today and go out and do something about it. And the second thing I'm going to say is cry once. People always say, oh, the price of getting a trust is expensive. It's not as expensive as going to probate. It's not as expensive as having to hire an attorney after the fact to go and try and claim your family's assets, plus the heartache and headaches that your family would be left behind. So when I say cry once, it means cry writing the check to Ed, but know that you don't have to cry ever again. Cry once. With that, thank you guys so much for attending tonight. We greatly appreciate it. LAPFCU, thank you for hosting us. You guys have a great night. And with that, we are off. Thank you, Ed.
Thank you. Good night, everyone.
Good night.